Welcome back to Legalese 123, where we are covering cases across America. Hello and welcome back to Legalese 123. I'm your host, Missy K. I hope everybody is doing well this lovely Monday, November the 17th. Woo! It's almost Thanksgiving. Well, I guess it's next week. So this is a reminder to you that if you have not purchased your Thanksgiving holiday treats, if you order some turkey from a specialized place, or if you order some pies and stuff, if you haven't do it now. You won't regret it. I do have to tell you this funny story that happened to me many Thanksgivings before. So also go out and go get all of your dry ingredients now. What does that mean? If you're going to make some pies or you're going to make some lovely stuff for Thanksgiving and you need to get those spices and all the lovely baking goods, go do it now. There was one time I was shopping the week of Thanksgiving. I think it was a Tuesday or a Wednesday. And I had happened down the spice aisle and there was no more cinnamon left. I kid you not. It was like there must have been the year where cinnamon was just nowhere to be found. And I witnessed this one lady go into somebody else's cart. I don't know if you call it a cart, a shopping buggy, a trolley, whatever you call your shopping cart. A woman had gone into another lady's shopping cart and had gone and gotten her cinnamon out of it. And the woman had turned around and had accosted her and said, "Hey, what are you doing?" And she literally acted like she did not know what the other lady was saying. And she was like, "Oh, I'm so sorry. I thought that this was my cart." And I was like, mm-mm. So I hightailed it out of there, got all the rest of my stuff and got out and said I'd vowed never to do last minute Thanksgiving holiday shopping, grocery shopping. So I plan well in advance. So this is your reminder, plan ahead. It won't be as chaotic this week or this weekend to just get your dry goods and then you can shop for your vegetables, etc. So this is your reminder. So what do we have going on today? What's going on today? So as you see, I'm wearing this lovely, lovely frock. I don't know if you can see, but I did not knit this sweater. This sweater was given to me by a dear friend, and I love it dearly. It was knitted by somebody in Ireland. I don't know if it was hand knit or whether or not it was machine knit. It's hard to tell. So, and I haven't done any big investigation on whether or not it is or isn't. But anyways, I adore it because it has lots of lovely different stitches and textures in there. So you've got some cabling, you've got some like a basket weave stitch. I don't know. Oh, let's see. Got some basket weave stitching right there. You've got some regular just knit stitches right here in the kit. And then you've got some moss stitching. It's an incredible sweater that has multitude of layers to it. So it's incredible. So what have I been up to knitting wise? Well, remember I had showed you a while back that lovely outfit that Tom Daly had worn when he was on the first show of his British knitting show. And so I have started my top for my, let's call it a capelet. So this kind of goes on the top of me, and then the other part will kind of go around, and then the cape sort of goes on, and there's no pattern for it. I'm just doing it off the top of my head, and we're gonna fasten it all together and see what it looks like. So it's been a labor of love. I have changed up some of the knitting stitches and what have you, and this is done flat, goes both ways. And and then here's just some 2x2 ribbing. I thought it was kind of cool. It's very neat. This yarn. Oh, I cannot it's so lightweight, so fluffy. It's going to be gorgeous. I cannot wait. So that is a project that I'm working on and hopefully we'll get it done. We have a holiday party that we're going to in December, and I hope to have that all together by then. Speaking of which, going to this holiday party, they're going to ask, "What is it that you do?" And I'm going to have to explain to them that I do this law 2B thing that I talk about different things that are happening in the world of crime. And so I would like to tell them that I just started this and that they're always asking, well, how many subscribers do you have? How many followers do you have? So I'd like to get to 50 by then, by the end of this month. We're at 23 today. So please do the YouTubey things. Do like and subscribe, leave a comment. YouTube doesn't even know that I exist. Somehow or another, you found me. Welcome in. So let's get started. So what are we going to talk about today? As I mentioned, Brian Walshe is in today for his pre-trial conference. What does that mean? So they're going to go over any last minute motions that they might have between the defense and the prosecution, iron out any of the small details that they might have lingering, and then they're going to talk about scheduling. They're going to talk about the voir dire. Voir dire means the jurors are going to come in. They're going to ask them questions. In this questionnaire, they're going to find out whether or not anybody knows anything about this case and whether or not they are going to be a good fit for the jury. I think they're going to pick 8, and we're going to see how that goes. Jury selection is scheduled to start tomorrow, but we're going to see in this pre-trial conference hearing what happens and what's involved. So again, it's sort of behind the scenes of what happens in a trial. There's lots of things that go on behind the scenes. There's lots of moving parts and lots of what we call casework that has to be done behind the scenes before you go ahead, and you don't just get up and start doing a trial. You have to figure out what evidence are you going to present. And again, what evidence is coming in from the prosecution? What is the defense going to try to state doesn't fit their theory of the crime? So all of that happens, and it's a great process. It's a theatrical process, right? You've got all this evidence that you say, oh, he's guilty, and then you've got all this other evidence that says, well, maybe he isn't. So it's reasonable doubt. So let's go ahead and let's start this pretrial conference hearing and see what we can learn from this, and we'll see what's going on. So let's do a road so far. Who is Brian Walshe? As we talked about this before, Brian Walshe was married to Anna Walshe. They had 3 children, starting in 2016, 6, 4, and 2. They had like a whirlwind sort of romance. This was not her first marriage. This is actually her second marriage. She is not from the United States. I believe she is a Serbian American. She was 39. She was a real estate executive. She didn't start off that way. She started off being a maid and working in hotels, worked her way up, and then she ended up working for Tishman Speyer in Washington, D.C. as one of her real estate executives. So here's how she became who she was. Again, hard work pays off. So 2022, she transitioned to Tishman Speyer in Washington, D.C. She was starting to sort of commute between Cohasset, Massachusetts and D.C., working between the 2 jobs, etc. Also want to remind you, Brian Walshe was in for a fight. He had apparently sold a fake Andy Warhol on eBay, and was accused of this crime, and was going to, in 2021, he was charged with his fraud. He was placed under house arrest pending his sentence. Later on in 2024, he eventually was given 37 months in federal prison plus restitution to pay. But this happened before then. So Anna Walshe was last seen on January 1st of 2023. They had a New Year's Eve dinner at her house. It was Brian, her, and a real estate friend of hers that she had in Boston. And then she went missing. It wasn't until 2 or 3 days later that Brian contacted the police and said, hey, she's missing. And so the police were doing their job and looking for her. In the meantime, again, these are the same investigators that are in the Karen Reed case. We've got Mike Proctor, whom you've heard a gazillion times about. Brian Tully, you've heard a little bit about him. Yuri Buchanan testified in Karen Reed's trial 1 and 2. Nick Guarino also testified in Karen Reed's trial, as well as Connor Keefe. We did a preliminary evidentiary hearing where we had these investigators come in and state how they found the information on Brian Walshe's phone, which is a bone of contention in his case. Brian states that he was giving over his phones willingly. There was a conversation between his lawyer and the district attorney as to whether or not what they were able to look at. Long story short, it seems that it might be coming into evidence. And then it's, it's like fruit from the poisonous tree. What did they find? So in his searches, they found his location data. He said he was at one place. They proved that he was somewhere else. And in that, then they went to these locations. They went to Home Depot, found the camera footage of him buying cleaning supplies. Why is he buying cleaning supplies? Then they found out that he was going to different apartment complexes. So they began looking in dumpsters. And one of the dumpsters, they found some articles belonging to Anna Walshe. And that I believe Brian had stated that's what she left with. Well, how did it get there? So in his trial, we'll find out exactly what they found and what all of that means in connection to this crime. Did Brian Walshe kill Anna Walshe? That is yet to be determined. Remember, he is proven innocent. He is innocent until proven guilty in a court of law. So you, as the juror of fact, get to find out what the evidence comes in, and you could decide whether or not you think that he is guilty beyond reasonable doubt, right? So we'll find out what information is going to come in. Why would he have killed her, right? The who, what, where, when, how, and why. Prosecutors believe that Anna was having an affair. We know that for a fact. In fact, her paramour is due to set to testify on the stand. What did he tell her? What did they talk about? Was she asking for a divorce? Did Brian and her have an argument that led to her demise? And then remember, her body has not been found. What happened to her? Where did it go? Don't know if we'll find out that answer, but we'll probably get some context clues as to what the police believe happened to her. Was life insurance part of it? I mean, here he is. He doesn't know what his federal sentence is going to be. Was she going to take the kids, and was she going to leave him? Did she want a divorce? Those are possible reasons as to why things went awry. Again, we talked about whether or not the warrants were unlawful in reference to his cell phone location, and then what the arguments were for his defense lawyer, Larry Tipton, and what the prosecution had argued in reference to the cell phone data. And then the judge had ruled that, yes, the searches and everything are going to come in. So let's remove this and let's go to the hearing, and let's see what we can glean from this. And let's figure out how we're going to start this. So here we go.
The motions that came in before weekend. All set?
Thank you.
For the record, the handcuffs have been removed.
Okay, we're going to pause there. I just need to make an announcement. Remember, this is a pre-trial conference. The jury, they haven't picked a jury. There's no jury here. So the things that they talk about in court aren't necessarily public knowledge. I mean, it's public knowledge because I'm watching it and you're watching it with me, but the general public doesn't watch these things. They don't know these things ahead of time. And if they did, could that be prejudicial? Could they say, oh, I watched this pretrial, I know everything about what's going on, I know the evidence and everything that's going to come in? That comes in with preconceived notions of what's happening. And can you be unbiased? Meaning, can you let what you know come into this trial and set that aside and say, hey, I know all this stuff, but I'm not gonna use it to make my decision. That's a very tough spot for a potential juror to be in. But anyways, let's go ahead and continue on. Sorry, my dishwasher is running, so you hear it in the background, but hopefully this will overcover it.
Fully participate in today's hearing. So the purpose of today really is to go through the motions and eliminate, see where I can give you some rulings and some expected rulings I always say expected rulings because I like to think of a trial as a living, breathing thing that evolves, not something that is pre-planned. So these are my best guesses.
Okay, sorry. One last thing. The judge is Judge Fernier, and wow, I just really like the way that she runs this court. She explains everything. She explains the process. She explains what she's doing. I think that is very, very genuine when it comes to a judge. That she's not all like high and mighty, and this is my court, and this is this and this that. She does rule very well and very fairly, and it's been refreshing to see since the Karen Reed trial. But I digress. Let's continue.
Sometimes I'm making actually affirmative rulings because I know enough that I don't think anything will change, but if it does change, I'll let you know. So I'll just start. I'm going to go through those motions that we went through a couple of weeks ago in the same order as they're listed. Instead of, I'll start first with the pretrial motions. And what we have left over there are the following. And before I move to the motions and eliminate, I'll give you an option to check in on others that you think that I might have missed. So the first motion that I think needs tending to is paper number 184, which is the Commonwealth's motion for use of streaming platform to prevent juror exposure to extraneous matter with an affidavit in support. The defendant did not object. The request is to use the standard Zoom format. The court intends to do that. And so that motion is allowed. There will be no other streaming platform used in this trial other than Zoom. Any questions about that?
Oh boy. So that is interesting. Oh, we're going to have to talk about that. Okay, so what does that mean? So currently, right now, there is what's called a pool camera feed. And that means that the media is in the courtroom. This is being streamed by Boston 10, I think, Law and Crime, all your regulars, right? They make a motion to come in and say, hey, can we go ahead and live stream this? And live streaming has been a bone of contention, I guess, a hot topic within many court systems. It definitely came up in the Koberger trial. It's coming up in the Corey Richens trial. And so here, Judge Fernier says, okay, if both sides agree to this, then we're just going to do a Zoom camera. And what that means then is the quality is going to be really terrible. And I was going to try to do gavel to gavel coverage, which is let's stream it like this on this well sort of higher quality. Now that it's going to be Zoom, you have to get into the Zoom link, and I'm not sure I'm going to be able to do that. So I might have to backtrack on that, but that might pose a problem for a lot of YouTube streamers like me. So let's continue on. But I understand the reasoning behind it. So we'll see. We'll see. It's her court. She gets to rule.
Briefly, there's the standard Zoom platform in which remote users are able to unmute themselves, and then there's the other version where they can't. I don't know what the name of that is. Are we using that version?
We're using the version that they can't unmute themselves.
Thank you, Your Honor.
Paper number 185 is the Commonwealth's motion for an order to prevent juror exposure. This is called the stay away, no contact order, so to speak. I don't know that we're going to need it. It's hard for me to judge what is going to be the appetite for either demonstrators in this case. I don't see anybody outside yet. And I'm hoping it stays that way, frankly.
Your Honor, I think the parties are all also hoping it stays that way. In the event that there's any information suggesting that there might be any sort of demonstration outside, how could we communicate that best to the court, information that we might—
Through the clerk. The best point of communication always is Madam Clerk.
Thank you, Your Honor.
So if things change outside and
Okay. So, as you know, this is the same courtroom in Norfolk County that Karen Reed was tried twice. And in that, if you don't know the Karen Reed case, long story short, she was being charged with killing her cop boyfriend. There were a lot of conspiracy theories and lots of insinuations that she was being framed. And Aidan Carney, who is a journalist slash blogger, had garnered a lot of attention for her case. And so therefore he encouraged people to come out and protest and demonstrate outside the courtroom. And what, not that that is a problem, it isn't so that if there's noise outside the courtroom, and this is not a very large, the courthouse is pretty large, but these courtrooms, they have lots of windows. So you can hear people outside. So they're saying if there are demonstrators, if there's something publicly going on outside that might disrupt the court or might influence the jury some way, maybe somebody says something, something comes out and they're like, no, Brian Walsh didn't do that, or he killed her, whatever the circumstances are. They don't want that to influence the jury. So that's what this demonstration thing is. As they're saying right now, there's nobody outside in court, so they don't think it's going to be a problem. If it does become a problem, how do they address it? Let's move on.
I have a skewed version of it because I sit out on the back, so I don't see what's going on out on the front of the building. But if it changes, you let us know and we'll, I won't hesitate to order that because of premier importance to me is keeping that jury that we pick in their fair and impartial state throughout the entire term of the trial. So the supplemental questionnaire, I'll get that to you today. I did add in, as requested by the defense, I changed those 3 questions to be 3 separate questions. I added in the additional question that the defense asked. I think we, at the side of the bench on Friday, the Commonwealth indicated to me that it didn't have any additional edits to that. And I did see some motions came in this morning. I can't say that I spent a lot of time looking at any of them, but I did see that there was a revised witness list, which the Commonwealth eliminated witnesses that it doesn't intend, it no longer intends to call, and added a few witnesses. Which reminded me, so I'm going to, that witness list as abbreviated, we talked about cutting out the custodian of the records and adding in the defense witnesses to the appropriate subheading. And I, not on Friday, but previously, I think I said to you that, said to the defense to take a look at where I put them to make sure that I put them in the right bucket, so to speak. Have you had a chance to do that? And are you content with where I put them?
I know I looked at it, Judge. I remember, but I think that it was fine. And I'll take a look at it before I leave today, but I think it's fine.
Okay. So what I'm probably going to do is take the new witness list from the Commonwealth and then add those people back into the same spots that I put them on the prior version, rather than try to figure out who the Commonwealth took off. But sometime this afternoon, you're going to get the questionnaire and you'll get the attachment that I intend to, and just take a look at it for the final. We can always make changes in the morning. And while I'm on the topic of questionnaire, I think I told you, I think it's the most efficient way to get the information to you, and the least logistically challenging way is the way I've done it really in almost every case that I'm using a questionnaire now, which is those questions are designed in a particular way such that a yes response requires further follow-up. And so when that person comes in, and I'm pretty sure now that we're going to be impaneling in this courtroom. I didn't think that the last time I talked to you, but based on what's happening in the other courtrooms, I can't get a clear courtroom somewhere else. So we are going to impanel in this courtroom. We'll be using the whisper technology for strikes. And when the person comes in and is seated, I will follow up on any missing information on the statutory questionnaire and any yes answers to the questionnaire. And then I have a few more follow-up questions if the person's still standing and is still a viable potential juror. One of the questions that I think I'm going to ask in that individual voir dire is to tell the prospective jurors that during the course of the trial, they need to agree not to be on any social media, and they need to agree not to watch the news in any medium. That's a big ask, but I think it's a necessary ask given.
Okay, so that is very, very good. I think that is very important. Why? So if you had watched anything or any hubbub about the trial for Donna Adelson, and one of the jurors said that she was on Tickety Talk, right? And she's like, well, I don't know anything about the trial or anything that because it was all on my For You page. And her For You page gives her, let's say she likes cooking content, right? So all of her For You was about cooking, and it had nothing to do with the trial or anything going on. Now, I'm not going to say that she lied. I don't know if she did or she didn't or what have you. But being on social media, you just never know what comes into your feeds, right? One minute you're watching about cooking and the next you got something about a beauty product. How did that get there? Or next you're talking about one thing and they're talking about politics, right? How does that get in there? So things get shuffled in when you're watching Reels or Instagram or TikTok or whatever. And so things just might pop off. And if something pops off about the Brian Walshe case in the midst of you scrolling through your social media, one would be like, oh no, I'm not going to look at it. But what if they did? So I think this is the wave of the future. You are not to look at your social media. Now, whether or not that equates that the person actually does that is a different question. But this is the new. Let's continue.
The level of publicity, media coverage in the case. Anyone have an objection to that?
No objection. Objection, Judge? Could I just ask a question, Judge? I looked at my notes from our last discussion. I read my notes to say you weren't going to give us copies of the questionnaire.
That's right. So how do I do that?
Yes.
So you'll have a blank questionnaire, of course.
Mm-hmm.
And so what I do is I have the person come in, I tell them in the impanelment script, you fill that out, give us your honest answers to the questions, you fold it together, and you keep that document in your possession. Don't show it to anyone until you hand it to me. So they will come up to the side of the bench, they will hand me the questionnaire. I will then recite. The juror number 40 answered yes to questions blank, 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 and blank. So you'll know what questions they answered yes to. And occasionally people don't answer and they'll put a question mark or they'll write something. And if that happens, I read literally what they wrote and where they wrote it. And if you at any point want to look at the questionnaire, that's fine with me too. I just want to prevent the both the time and the paper that's involved. Jury selection is so paper intensive anyway. The last thing you need is more questionnaires. But if you want to look at the questionnaire at any point, that's fine. And then at some point, the very last question, as you know, on the questionnaire says, whether this would disclose anything that would be personal to you. I presume that some number of jurors are going to answer yes to that question. At some point, typically at 1 o'clock, I will have the required hearing under URIP to seal those questionnaires. And you have to give, under the rule, you have to have a hearing. So it'll take about 2 minutes, but we will have that hearing at some point during the early stages of the trial.
Thank you, Judge.
So again, just quickly, this is another way that she controls her courtroom. Each judge does their things a little bit differently. I appreciate her wanting to spare the world of the paper that the that's generated by this. I also like the way that she then has the paper. She controls the narrative here. Not saying that that's a bad thing, just that she has control of things and she is monitoring what's happening. And she's, to me, it sounds like she's taking the jurors very, very seriously. So let's continue.
The Commonwealth filed a preliminary request for jury instructions. I just want to bring that to the defense's attention with regard to the elements of all of the crimes, so that if there's any objection to that, the murder one is really the SJC's. And I don't know that you're going to be dabbling with that, but with regard to the others, just take a look at those so that we're all on the same page with regard to the elements that are attenuate to the other crimes, all right?
We have, Judge, and at the appropriate time, we do have an objection to some of their requests, but we'll deal with that when that wants to.
Okay. I think we're a little before that point, but I'll be happy to hear you whenever you want to bring it to my attention. We've dealt with on Friday the motion for change of venue. And we also, I guess implicitly, if not explicitly, have addressed the defendant's motion for leave to conduct attorney-conducted voir dire to the extent that the defense is asking for panel. I'm not going to exercise my discretion. I'm going to do the traditional individual voir dire. And of course, you play a big role in that.
Okay, so what does she mean by that? So there are different ways that they conduct a voir dire of the jurors. Sometimes they get a whole bunch of them, they put them in a box, they have the questionnaire, and they ask them questions right out in front of everybody. That sounds, I think that's what she's referring to, that she doesn't want to do that. Or they sit in sort of where the audience is and they just go through things and start like picking people off one after another. I don't think she said that she's going to do that. She wants to have the paper, the questionnaire. She wants to look at it, ask questions and what have you. Now, what takes longer? I don't know. I'm not a lawyer. Don't quite know what's going to take as much as what's going to take as much time. But to be honest with you, it really, really sounds like this is the way she does it. She wants to be very thorough. She wants to make sure that she gets the right jury for this case. And I think she's handling it very intensely, very cautiously, and she's very concerned and wants to make sure that it's done right, which rightly so. So let's continue.
That's all I have for non-motion in limine pretrial motions that I think that I could give you some rulings on. Before I move to the motions in limine, is there any other non-motion in limine pretrial ruling that you're looking for?
Your Honor, the Commonwealth did file a motion for reciprocal discovery.
Okay.
The defense did provide us with the notice of intent to call Dr. Banerjee and an outline of Dr. Banerjee's opinion if she testifies. The Commonwealth is requesting the proposed potential testimony of Dr. Lakin and Joel Scoletti of Safos Corporation, who are identified as potential experts by the defendant, and also Dr. Dan Feria and Steve Verino of MVP Forensics, also identified as potential defense experts. And also Tim Creamer has been identified as an investigator. Commonwealth is requesting any statements that Mr. Creamer has obtained and also the substance of any testimony he may offer.
We have no opinion, we have no reports, we have no statements. I will, though, provide them with a summary of what I anticipate the other experts would testify to. I'll do that.
All right, when can you get that to them?
Pardon?
When can you get that to them?
Wednesday?
Seems reasonable.
Sorry, my mic was muted. All right, want to pause there just really quickly. So I'm not sure who this person is. I think this is Laura McLaughlin, and I think this is Mr. Connor, and I'm not sure who she is. I didn't see them say who they were, and eventually we'll get there. But what this is the district attorneys. Oh, I don't know if you can see my mouse. These are the district attorneys, and these are the defense lawyers. These are the district attorneys who are prosecuting. These are the defense lawyers. What she is asking is, hey, listen, you're going to have all these experts come in, and we have no idea what they're going to say. And as part of the discovery, you're supposed to, if they wrote up a report, they're supposed to say, I did X, Y, Z, and I came to this conclusion X, Y, Z. And Mr. Tipton said, they don't have a report, Your Honor. And sometimes that can be good because then the defense is sort of on the back foot being like, okay, they didn't have a report, so what the heck are they going to say? In discovery, you're supposed to kind of have an idea of what the witnesses are going to say in order to ask them questions, right? You can't just get on the stand and say a whole bunch of things and blurt out things that may or may not be relevant to the case. You have to have a pre-notion or pre-context of what they're going to say so that you can dispute that. You can ask them questions to sort of poke holes in what they're going to say. So Mr. Tipton says there are no reports, which I find very interesting. So what is it that they do and what are they going to testify to? But then he'll give the statements or what he's going to ask or what they're coming in to say to the prosecution so they have an idea of how to counter that. All right, let's continue.
Any other non-motion and limine motions? All right. So I'll move to the motions and limine, and I'm going to take them in order, I think, with the exception of maybe one of them. When we get to it, I may pull that to the end. So paper number 187 is the Commonwealth's motion to limine number 1. It's to provide the jury with a means to review electronic exhibits during deliberations. And the defendant did not object to that as of at least 10/31. Same position today, right?
Yes.
It's allowed. The Commonwealth needs to ensure that the laptop that is in the jury deliberation room is contains no other information other than the information that's necessary, the software that's necessary for the jury to review the material evidence.
We will do that, Your Honor. There is a special laptop that will be used for that purpose, and it will be provided to the defense to inspect it.
All right, and that was the second part of my order, which is the defense is ordered to review that laptop before it goes in to make sure that we don't have any glitches. Paper number 188 is Commonwealth's motion in limine number 2. It's to notice of any visual aids defense intends to display during opening statements. The defendant objected to that. Is the defendant still objecting to that?
It is. We are.
The motion is allowed. As to opening statements, I want to see any chalks that you're intending to use. It's for your own good. Because if I determine that there's something on that chalk that is inadmissible, you are not going to be able to use it because you're not going to be able to turn it around. Go right ahead and state your objection on the record.
Well, Judge, I would just like to explain something. I object to it for a very simple reason. I've been doing this for 20 years. I've never had an objection in either my openings or my closings when I've used visual aids. Secondly, I only include visual aids that I know are going to be exhibits that are admitted. If I have any question about anything that I would use visually for the jurors, I approach the DAs, I approach the court, make sure that we're all in agreement that's an exhibit. I don't use
Then why are
charts.
you objecting to it then?
Because it gives, if I give it to the Commonwealth before I make my opening, they have a roadmap, they have a preview of what we're going to say.
Everyone's supposed to be getting a preview of the evidence.
Not of my opening and not of my thoughts.
All right, I'm not going to engage in a discussion about this. Any chalks that you intend to use that are not agreed to exhibits need to be shown to the court and to opposing counsel.
Okay, Judge, just so I understand.
And it can be the morning of, but it's going to be before you're holding something up in front of 16 jurors that we spend 2 weeks picking a jury for.
No.
Not happening.
And I don't want it to happen, but let me just clarify something. I understand the court's ruling so far. Chalks, but not what we know to be exhibits.
If you have, and I know you have, agreed to exhibits, then you don't need to address that. Those are
Fine.
agreed to. You know it's agreed to. You can show those.
Fine.
If you have chalks, different thing, that you want to put in front of the jury, I am not letting you stand up before the jury without me seeing it first and the Commonwealth see it first. It can be the morning of, but I do not want you showing a chalk to our impaneled jurors without me seeing.
Okay, so what are chalks, right? That is sort of the Massachusetts word for like demonstratives. They're going to show you, oh, hey, this, and that. And Larry Tipton is like, hey, Judge, I don't want to show my hand. It's like a poker game, right? I don't want to show my hand and let them know what they have before we start betting. I want to show it right when it's going to be up and be like, here you go. And Judge Fanier is like, oh, no, you're not. You need to wait until we need to see it first, right? She doesn't want any surprises in her courtroom, right? I don't blame her. So she understands that she doesn't want him to tip his hand, but yet he needs to show what he's going to show to everybody. So it's not like super prejudicial or it's going to be inflammatory and create a kerfuffle amongst each other. So in fair play, the DAs, prosecutors have to show the defense and the defense has to show them. So it's kind of a heated battle. Let's see. Obviously, Judge Fanier says, no way, Jose. So Larry Tipton's just going to have to she's a judge. She rules her courtroom. Let's continue.
It first.
I understand, Judge.
All right. Paper number 189 is Commonwealth's number 3. It's for notice of any third-party culprit evidence. The defense has indicated that he understands what the rules are and you're going to abide by them. There's no ruling necessary. Paper number 190 is Commonwealth's number 4, notice of any proposed reputation testimony. It also relates to, I have them in my notes, see paper number 193 below. 193 refers to any bad character, bad reputation of the victim or any of the witnesses, and alleged prior bad acts of the victim or any witnesses. The defense has objected to that, arguing that he intends to bring in evidence of general reputation evidence. Is that right?
Your Honor, at this point, we don't have any notice of specific reputation evidence that we'd either offer through cross-examination or in any case in chief for us.
Okay.
The concern I do have is the Commonwealth has indicated they expect to introduce evidence, quote unquote, that Anna Walshe was a loving mother who would never have abandoned her children and was a dedicated employee. So I'm sure the government is aware of the restrictions on how this evidence will come in, but that may or may not be relevant. And so I'd ask the court to revisit this before they seek to put this information in.
All right, Commonwealth.
Oh, interesting. Okay, so see, this is where you get to hear like prior things prior to the trial, right? So the defense is like, oh, she was a great mother. She would never abandon her children. She's so loving, etc. Blah, de, blah, 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 blah. And they're like, no, wait. So again, it is a dance, right? It is how you present these people, how their lives were, and what happened, right? So they're not saying they're not necessarily going to dishonor Anna Walsh, but they need to paint a picture of who she was. She was having an extramarital affair. She wasn't home a lot. They had a nanny who took care of the kids. Is that what a loving mother should do? But she's also, again, it's don't come for me. Don't come for me. Many women work, and there's nothing wrong with that. But this is somebody's life is on the line. This is Brian Walsh's life on the line. And so they're going to see how they're going to paint the picture of who Anna Walsh was and who Brian Walsh was. And so they're saying you can't besmirch this person, you can't defame them, but something of this has to come in. So let's see what the district attorney's office, let's see what the prosecution has to say. How is this evidence going to come in?
Thank you, Your Honor. Your Honor, the Commonwealth does plan to call witnesses who will testify as to their observations of the victim at her employment. Her employer will testify, as well as her former employer, who was the New Year's Eve guest, will testify as to her.
Is it Metlu or Mutlu, or how do you pronounce his last name?
Mutlu, Your Honor.
Mutlu?
Mutlu.
Okay, I'll try to remember that.
Thank you, Your Honor.
The Commonwealth will be introducing evidence to those persons regarding the victim's work ethic and
Observations or interactions with the children?
yes, Your Honor, observations and interactions with the children.
All right. I'm not going to give you any firm rulings on it. You raise your objections at the time. I will tell you generally that I probably will allow observations of her, not to an excessive amount, whatever that in my mind becomes excessive. But general observations as to the victim's interactions with her children is permissible.
Your Honor, I would just add that the law is clear on this. They can't have specific acts. So an observation would be a witness giving their opinion or testimony on a specific act. And so that's not admissible. What they're allowed
You're right, opinion or testimony.
So observations, how are observations of her with her children relevant, which I suspect may or may not be relevant once we start? And it can't just be a limited number of people. So one person from her work saying that she had a good work ethic, the case law says you cannot do that. It has to be the general reputation of a community. And so I guess we will just raise the objections at the time. I just wanted to put the court on notice that
Right.
any of this testimony could just be inflammatory and prejudicial and invoke sympathy of the jury to hear that she was a great mother and a great employee.
All right. I hear your objection, and I encourage you, and I know that you don't need any encouragement to make the real-time objection at the time of the trial. And I'm just trying to give you some basic guideposts of what my present thinking is with regard to that evidentiary issue.
Okay. So again, see, this is really interesting. This is what we learn, right? This is how trials go. So the defense or the district attorney's like, hey, we're going to bring in these people to say that she was this great person, and we observed her being a great person. And the defense is like, well, that's okay, but if you get into specific moments of, oh, she did this and she did that and she did this, and it paints her as this lovely picture, and again, he's the monster and she's the lovely person, that you can't come into that. That's talking about bad character evidence. So, well, again, so now you know. So if you watch the trial, you'll see how that evidence comes in, and you'll hear when they object what that means. They're objecting and saying, "Hey, we've crossed the line here. This is not admissible." So we'll see how that plays out in trial. See, very fun, interesting. Let's continue.
The, anyone want anything more on that particular motion?
No, thank you.
Not at this time, Your Honor.
Commonwealth's number 191, motion to eliminate number 5, is to allow in-court identification the defense asked for, and the Commonwealth has now given, I see this morning, a witness list of the witnesses who will so identify. Any issue that I need to be aware of with regard to that?
No, Your Honor.
All right. So that motion is allowed without objection, and the Commonwealth has satisfied the defense's request to provide names as
Okay, so what does that mean, identify? You know, when they come into court and they say, do you know Brian Walsh? Yeah. Can you identify him in court? Yeah, he's the dude sitting over there with the glasses and he's got this blue or black suit on. That's what an identification means. There's case law in reference to that, as to that there were some cases in which the person came to the stand and like, do you see that person in court? And they're like, no. And then what? And then there's some cases where they don't identify, and you're like, wait a second, that you need that for the record. So it's a very important case law fact. All right, let's continue.
of this date. Number 6 of the Commonwealth's motion to eliminate is to preclude reference to or introduction of irrelevant conduct of testifying and non-testifying police officers and agencies. The defendant objects, and I'm happy to hear further argument on this if you wish, but the defense's objection to me was, I wrote in my notes, it depends on what the Commonwealth does in its case in chief. And so you've alerted me to the issue, and we'll take it as we go along. With regard to a preemptive ruling in that regard, nor do I think that it would be part of your opening statement, because the opening statement is supposed to be a preview of what the evidence in the case will be. And so the defendant may not open on this without raising it with the court. It wouldn't be expected testimony at this point based on your opposition, or seek to introduce that evidence without readdressing it with the court affirmatively at the time that you're going to do it. All right? Commonwealth's number 7 is paper number 193. I think we just went over that with.
Okay. So I'm not sure about that one. Sounds like the Commonwealth says, we only want these officers to testify. And those in the case in chief, right? Those who had a hand in what transpired. And that other officers shouldn't come into play because not have handled the case. And what does this all surround, right? Let's say it all together. 1, 2, 3. Michael Proctor, right? So Michael Proctor had a little bit of a hand in this mess, in this case, I should say. Ooh. We know that Michael Proctor's texts came in. They are exculpatory to Brian Walsh's case. We don't know exactly what was said. We don't know how that is going to come in. Obviously, the district attorney's office doesn't want any of those things to come in because it is quite prejudicial, and it makes it seem like Michael Proctor had a bias towards Mr. Walsh. I'm speculating here. We don't know what's going to come in. We don't know if that's going to be a case or what. And again, we don't know exactly what Michael Proctor's hands were in this case. We talked a little bit in the preliminary evidentiary hearing where there was Guarino, Keefe, Fanning, and Buchnick, but Proctor was not involved in that. But Proctor did write some of the warrants. So Proctor will come in here and there, but whether or not he's going to be a bigger character in this case versus Karen Reed, we don't know. I don't think that he was the lead investigator on this. I think I think Buchnick and Fanning might have been like the leads on this. So I would assume that the district attorney's office want to exclude anything to do with Michael Proctor because I mean, obviously he has done some unrepairable things. He's been a fired, disgraced Massachusetts state police officer, and they don't want to have him anywhere near any of their cases if they can do that. Again, this is going to be the very first case since Karen Reed and all of the text messages that have come out where Michael Proctor may or may not be center stage. And so I think that the district attorney's like preempting saying, hey, if Michael Proctor wasn't a person in a person of chief in this case, we're not going to call him. We're not going to talk about him. We're going to avoid him like the plague. And it also depends on what Larry Tipton knows and whether or not that's going to come out. So again, it's going to be very interesting. Let's continue.
The other one, so I'm going to bypass that. Paper number 194 to Commonwealth number 8, to admit photos of digital devices rather than the actual devices, and the defendant did not object, and that's current today. That motion is allowed without objection. Let me pause on 195 because I think we're going to have to go through. Let me just say, first of all, Commonwealth number 9 is to admit the defendant's 4 recorded interviews with the police. I saw this morning, but I haven't really had a chance to look at it. The Commonwealth supplemented its legal briefing with regard to statements of Miss Minor and of the minor child. I want to look at that, and I want the defense to have an opportunity to look at that. I looked the case over quickly this morning, but I frankly didn't have much time to deal with it. But I'm going to circle back to that motion because I think we're going to have to go sort of on the micro level and start going statement by statement, which is going to take some time. So I'm going to put that towards the end of this hearing. Paper number 196 is Commonwealth number 10, to admit NCIC missing person form for Anna Walsh. Defendant didn't object, correct?
Correct, Judge.
It's allowed. Paper number 11 of the Commonwealth's motion in limine, to admit photos and a short video of Anna Walsh as she normally appeared. The defendant objected. So I haven't seen the video. Does the Commonwealth have a way to show me the video?
I believe we could email it to you, Your Honor.
I meant like right now.
Your Honor, I have it on my computer. If you can give me a moment, I can walk up to the bench.
That'd be great.
Yeah.
Generally, what is the video of?
It's her with her 3 children on a rug in the living room of the home.
And why is it important?
The rug, an identical rug was found in the dumpster outside of the defendant's mother's home.
Your Honor, I can approach, but just what might make it easy is the video is unnecessary. They could do a screenshot of the video which portrays the rug in question. If I could approach it, I can show you.
Yes.
Yeah, sure.
Okay, so let's talk about this for a quick second. What is the contention here? So the contention is they want to show this video of the rug. But it also depicts her and her children on the rug. One could say, oh, again, she's such a loving mother and she's with her children on this rug and oh, but if the purpose of the prosecution to bring in this evidence is just the rug, right? So what the defense is saying is, hey, listen, just screenshot this and show that this is the rug that was in the house, and then this was the rug that was found in the dumpster, just to go ahead and make that connection. Don't show the video. So let's see if we can kind of zoom past this a little bit here.
No objection.
All right.
I think it's incredibly inflammatory defamatory. And if their sole reason for introducing that is to simply show that that rug was in the home, they can do that with a screenshot.
No objection.
All right. That's the ruling you were going to get. So it's good that there is no reason that the video needs to be played. So just take a shot of it, show the shot. Now,
I'll sit
with
down.
regard to the other photos, you need to use, it's sort of like autopsy photos, in my view. Use the least number you can use to get, I understand that's one picture she's wearing a necklace and one more picture she's showing the watch or something else. But use the least number that you can use.
If I may, Your Honor?
Yes.
So I agree with that, and we tried to cull it down. So there's one with a jacket, there's one with a watch.
The black jacket.
Yes. There's one with a watch, and there's one with a necklace. We can probably take away one or two from what we submitted, because I believe that there's one where she's with Mr. Mutlu wearing the watch. So maybe we can delete that one. So we're talking probably about 4.
Your Honor, the other issue is those photos can also be cropped, and there can be a stipulation that the cropped photograph showing a person wearing the necklace, the coat, is in fact a photograph of Anna Walsh. So they have sent a parade of photographs. I think that there's other ways to serve that purpose, and some might be stipulations. So this,
Well, I'll let you work out whether you have any stipulations, but even if you want it that way, doesn't mean that the Commonwealth wants it that way. And the Commonwealth gets to, hold on one second. I gotta take a break.
okay.
Okay, so obviously Judge Vernier has another pressing matter, but I'm going to pause it there. We'll zoom past this because that's why I waited for everything to come through and zoom. What the defense wants is they don't want her picture out there, right? It's the same thing with the video. When you continue to show pictures of a person, you sort of like, I guess you kind of humanize them, right? And in some ways, they should humanize her because she is deceased, right? She can't speak for herself. But when you continue to introduce and flood the jury with all of these pictures, et cetera, then they start to get an attachment, an emotional attachment to this person. And you can't have that, right? Again, it's called prejudicial than probative, right? It means that if you are on a jury and you are giving your vote, whether guilty or innocent, based on your emotions, that is considered wrong. You're supposed to look at the totality of the evidence, and based upon the evidence, you need to say, yep, I see the Commonwealth has said it's like Clue. He did it in the Brian Walsh did it in the library with the wrench at whatever time, right? You have to have the significant clues in order to say, yes, beyond a reasonable doubt, yes, he did it. If you are flooded with emotional things that could impair your judgment, that's not good. So let me see if I can zoom and see if how we can get this back going for us. All right, here we go.
All right, I think I was saying that you may be able to reach a stipulation. I don't know if you can, if you can't. But I think I was just about ready to say that the Commonwealth gets to, within the bounds of the evidentiary bounds, gets to present their case.
I appreciate the analogy to autopsy photos. And so let me go back and see if I can do something that's more palatable to the defense.
That's frankly how I see it. I mean, I understand the significance of the various items that we've just listed to the
Yes.
Commonwealth's case, or I think I understand generally what the significance is to the Commonwealth's case. So I'm inclined to let them have the photos at.
Okay, I think I failed to mention why these photos are important. The watch, her jacket, etc. These are items that were found in the dumpster. So when the police got his location data and saw that he was at his mother's apartment dumpster and then like somewhere else, they had found a rug and then a purse of hers and some items of hers in this purse. And they are just equating, hey, these items belong to her. They're trying to make that connection, which is rightfully so. That's their chief, and that's their case, right? These objects belong to her. She normally wears them. This, therefore, how did they get there, et cetera? And you get to make the context clues. So let's continue on.
They're going to need to make those arguments, but they don't need to be inflammatory. And so, yeah, just look through the lens of an autopsy photo.
Thank you, Your Honor. I
Comparable.
appreciate that, and I'll work on it.
All right. Commonwealth's motion number 12 to admit evidence concerning the defendant's federal charges. And the defense is opposing in part. I'll hear from the Commonwealth first on this one.
Your Honor, we have actually attempted to develop a stipulation. The Commonwealth had sent it to the defense, and we haven't heard back as to whether that is something they wanted to stipulate to. We had been working on potentially reaching an agreement as to what information about the federal charges would come in.
All right. Well, to aid you in your discussions, it seems to me, and this actually overlaps with regard to the one of the other motions with regard to the interviews. I understand the importance of the federal case in terms of the Commonwealth's argument with regard to motive, and particularly the timeliness of certain information vis-a-vis the time that the Commonwealth indicates that they believe the defendant did the acts that he's charged with. And the one area that I wanted to probe so that I have the information firmly in my mind, what the evidentiary significance of it is, the weight of it versus the prejudice, is the GPS. So my memory from prior proceedings on this case is that the GPS was not the way that the Commonwealth found out that Brian Walsh was at various places.
That is correct, Your Honor.
All
It
right.
was not a GPS bracelet.
What was it?
It was a radio frequency bracelet that would go off if he went a certain distance from the home, and he would have a allotted amount of time to leave the home to perform errands and drive the children.
Okay. So there's no evidentiary, there's nobody coming in and saying based on how his bracelet, he was at X, Y, and Z. They found that from the phone, right?
That is correct, Your Honor. They found
All
it
right.
through the two phones.
So that seems to me to be both in the transcripts and also just to the extent that it's in any of the federal papers as a condition of release, highly prejudicial. And I'm not inclined to let the jury hear about that. It's not relevant to their decision-making, and they may, even if I give them a limiting instruction, may make it difficult for them to accept the limiting instruction. It doesn't have any evidentiary value.
Okay.
So anything with regard to both in the interviews, which I know we're tabling for later on, and or in the federal records, that seems to me to have very little evidentiary value to the Commonwealth and has a potential for prejudice to the defense. So that won't be in.
Understanding you've made a ruling, can I make an attempt to change your mind?
Sure.
All right, thank you, Your Honor. I appreciate you giving me this opportunity. So with the defendant's ability to have windows of time that allowed him freedom to leave from the house, it allows the Commonwealth to show the premeditated nature of this crime and that he had windows to clean up after the crime was occurred.
That's a different thing, though. The fact that he has windows of time that or certain parameters that he has to be at home, and that comes up in the interview at one point when Attorney Minor makes mention of
Yes,
that. And I don't know what we're doing with that yet, but
okay,
putting that to the side, I don't think that what you just said about windows is the same thing as I'm saying about being on an electronic bracelet.
okay, okay. Because
I think there's different prejudice that attaches to those two things. The fact that he had restrictions, that he was on federal supervised release, and that he had some restrictions is going to be known to the jury. It's integral to the case. But the fact that he's on an electronic monitoring bracelet is a different thing
okay,
in my mind.
thank you, Your Honor. I understand your rule.
But
Okay, so that is very interesting. I don't know if I I kind of knew that, but I wasn't quite, I knew he had restrictions about his timing, sort of like when you, you commit a crime and the judge says, all right, you're only allowed to go out during the hours that you work, only 9 to 5, and that's it. And you're not allowed to go out beyond that. Well, now they've got all these electronic monitoring GPS things. And so that's what he's saying. He had like he obviously must have had an ankle monitor, and he talks about radio frequency, that if you're out of bounds by this particular time, it goes off, etc. And so that's interesting that so the defense sort of won that. So again, it's a dance, right? The Commonwealth wants these things, this evidence to come in, and the defense says, no way. That's going to leave an impression on the jury that says, it could be like bad character. He's a bad person because he's got this electronic monitor bracelet. Obviously, this bracelet thing's going to come in, but she's saying not in this context that you want it to come in, that this radio frequency also is a contributing factor to his GPS things, where they're saying it's premeditated. You're going to have to find a different way to get that in. So the defense won that one, which is pretty good. This is what the dance is all about. What evidence can come in and what evidence can't come in. So let's continue on.
keep on objecting, as I know you will, but that's sort of the dividing line that I'm drawing in my mind's eye right now. And keep on working on the stipulation.
Yes, Your Honor.
Paper number 199 is Commonwealth's motion in limine number 13. It's to admit the victim's out-of-court statements, evidence of her state of mind, and the defendant's motive to kill her. The defendant is opposing it in part. I'll hear from the Commonwealth first.
Thank you, Your Honor. The Commonwealth would seek to introduce the victim's out-of-court statements to Alyssa Kirby and to Mr. Mutlu and to Mr. Fastow as to her state of mind, which was known to the defendant. Your Honor, certainly the defendant, the evidence will show that the victim had a meeting with a friend, Ms. Kirby, on the 29th of December and told her about the big argument they had over Christmas.
Give me a timeline because I want to have this in my head. She comes home on Christmas Day.
Yes.
Anna comes home on Christmas Day. She drives because she missed the flight. She spends much of the day driving, and then she gets there on the afternoon, evening of the 25th.
Yes, Your Honor. I believe it'd be around 8 o'clock.
When did she drive back?
She leaves on the 26th of December,
Okay. And she drove back to DC.
and she drove back to DC
And then she returns back to Boston by flight on the 30th.
on the 30th.
All right, that's helpful. All right, go ahead.
Your Honor, on the 29th, when she's still in DC, the night before her return to Boston, she goes out to dinner with her friend Alyssa Kirby and talks about the big fight that she and the defendant had, and tells Alyssa Kirby.
She'd been home for Christmas.
Yes, over the Christmas break, or the day that she was home. She tells her about that big fight, that she gave the defendant an ultimatum, that she had learned that the reason the children weren't with her was because of the defendant and his attorney, and that she had told him essentially to just resolve the case, even if it meant taking jail as a result. And I know Your Honor has reviewed the paperwork, and it is a little more detailed, some of the
I have.
statements at grand jury. Your Honor, I would suggest that this is admissible because certainly it shows the victim's state of mind, that she is prepared to do what she needs to do to take her children down to DC to be with her. She had a very highly compensated job, and I know Your Honor is familiar with the circumstances of her moving to DC without the defendant and the children. I suggest that that is certainly known to the defendant. He acknowledged and alluded to a big fight over Christmas in the recorded interviews, and indeed said that he had learned after fighting with the victim previously over Christmas, and I believe he said Thanksgiving, that he was not going to fight with her over her alleged need to return to Washington, D.C. for a work emergency. Suggests this is highly probative of the victim's state of mind and the defendant's motive to kill her. It also shows that he is aware of this. He's searching Mr. Fastow's name. He's searching for divorce, and he is conducting those searches in between. I believe the search for Mr. Fastow was on December 25th, and then he's searching for divorce, I believe, on the 27th. His mother then hires the private investigator to investigate Anna's, whether she's behaving appropriately for a married woman. That's on the 28th. Certainly suggested all of this is highly relevant to the victim's state of mind and the defendant's motive to kill her and what happened in that home on the 1st of January. And with Mr. Mutlu, there is some testimony about Anna Walshe had some conversations with him, I believe, on the 28th. And Mr. Mutlu's testimony is a bit indicating in some of his statements that some of it he might have learned from other people, but some of it he did learn from Anna. And certainly the Commonwealth would be very careful to make sure that we were only eliciting what he learned from Anna, not something he had heard from somebody else. And I suggest that that should all be admitted in this case.
All right. Defense?
Thank you, Judge. Your Honor, the problem I have is the Commonwealth is also cherry picking parts of these conversations. The dinner that they're speaking about, her and her friend were out until 1:30 in the morning, a night that ended at a karaoke bar. So there was probably copious amounts of alcohol, I would assume.
But that goes to the weight the jury chooses to
It
give
does,
to it.
But in the context, I think it's important. The other thing that the Commonwealth didn't seek to introduce is the fact that Alyssa Kirby at the grand jury, at her grand jury testimony, said that they had a very open and honest relationship, and that Anna wanted him to do whatever he had to do so the family could be together. And further, she didn't say that she wanted a divorce or was going to leave him with this ultimatum. Specifically, Anna supposedly said to Alyssa Kirby that she wanted him to choose life because he had been so depressed. And even if he had to go to jail, that will be waiting for you when you get out.
Mm-hmm.
So I think they're not only cherry picking what portions of this conversation they want to put in, they're overstating the relevance, especially in light of the case law. When you look at the cases that talk about state of mind, they cite Castano. That was a situation in which the witness had told the defendant in that case that she wanted to end the relationship, that she had rejected his anniversary presents, not only was ending the relationship, but has packed up his bags. And when the police responded to the scene, there was in fact a packed suitcase of the defendant's items at the door. That is not what we have here, let alone to that level. In Martin, the statements that the government was seeking to introduce were basically statements in history of physical abuse, violence, of her trying to take the children from him. That is not what we have here. Half of the conversation to Miss Kirby was how she wanted her family together. They had an open relationship. Couples fight. So to say they had a big fight on a date, she was late for Christmas and they had 3 children. This was not earth-shattering motive to kill information. So I don't think it's fair that these conversations with Alyssa Kirby come in. And certainly if the court does see value in those statements as the case develops, then the doctrine of verbal completeness would force the court to allow all those statements to come in. because this was one conversation. So that would be our position with respect to Alyssa Kirby. With respect to Jem, I think there needs to be either a voir dire or some clearing up of what he heard from other witnesses and what he specifically heard from Anna. And again, Mr. Mutlow was with them on New Year's Eve into the 1st of January until about 1:30 in the morning. And he's also described the night is joyous, that they had a happy marriage. The federal case had been going on since 2018. They had been weathering this storm. And so again, if they're seeking to introduce statements, I think that the full conversation would come in to show the context, and we need to figure out what exactly Mr. Mutlow heard directly from Anna.
All right. So let me give you some guideposts. The defense in its opposition cites to Qualls, which is sort of one of the earlier and seminal cases on state of mind evidence. And, but I'm not persuaded by the defense's argument with regard to what Qualls stands for in light of Castano and in light of, which for the record, Castano's at 478 Mass 75, a 2017 case, and also look at Commonwealth versus Bins, B-I-N-S. That can be found at 465 Mass 348, a 2013 case at head notes 17 through 22. Under that case law and other cases that I looked at, it is very likely that I'm going to allow Anna Walsh's statements to Alyssa Kirby, the limited purpose of establishing her state of mind as is relevant to the defendant's motive to kill his wife, to the extent that such state of mind evidence includes statements describing his defendant's prior bad acts. His federal case on his statements will be admitted, and with a limiting instruction that it is limited to show the defendant's motive and not to show that he had a bad character or propensity to commit any other criminal offenses. There's a limiting instruction that is posited by the court, the SJC and Benz. It's on the bottom of top of page 419. Take a look at it. That's what I'm likely going to give you. I think that the parties need to do a little bit more work with Jem, and they will, as the Commonwealth gets ready to prep him for his trial testimony, and obviously be in touch with the defense with regard to what that pretrial work reveals with regard to statements that were made directly to him from Anna, as opposed to third-party other evidence that would not be admissible.
Yes, Your Honor.
With respect to William Fasto, there's one notable exclusion or sustained you're going to hear. The statement that she makes to Mr. Fasto about she doesn't know what the defendant would do if he were to find out about the affair is not her state of mind evidence and is not admissible and is
Understood.
prejudicial. So don't go there.
Yes, Your Honor.
And then, of course, with regard to the doctrine of completeness, I think the defense has an argument there. And so I'm inclined to let them bring in the other statements. And you can oppose it if you want, but that's sort of the guidepost that I'm setting right now.
Understood.
Okay, so that is very interesting. That is very interesting to tell there. So the Commonwealth said, "Hey, we want these conversations to come in as to the state of mind of Anna Walsh from these three particular people. Kirby obviously is her friend. Mr. Mutlow was a colleague of hers in Boston, and Mr. Fausto is her paramour." So again, I said earlier, I was curious to find out what his thoughts and what their statements were and what's going to come into trial. So the Commonwealth won some of that, the defense won some of that, and then there's a meeting of the minds in between. So Mrs. Kirby's statements will come in, but the Commonwealth can't cherry pick them, just as the defense said. If she made a big long statement about everything, all of that gets to come in. And so how it comes in is perhaps maybe the Commonwealth asks certain questions geared towards these things. The defense asks the other questions. Well, didn't you say this and didn't you say that? And the whole full statement comes in. You can't just say, oh, this nail polish is black, and they're like, no, it's not, it's orange. So you have to give the full picture of everything. You can't just cherry pick things. As far as Mr. Mutlu, again, it's a little bit muddied there. He doesn't know exactly what he recalls from Anna. It has to be direct from Anna. And if you get, well, this person said this and this person said that. Remember, we were talking about Kelly Dever, and she was like, well, I don't know what I saw or whatever. And the judge was like, well, you have to rely on your memory, right? So that is what Mr. Mutlu, he has to rely on his memory as to what he and Anna's conversations were. And she mentioned a voir dire. And what that means is, if they're not exactly sure exactly what his statements are going to be, then he can come in and sit on the stand and he can testify. They can ask him a whole lots of questions. It's not in the presence of the jury, and they can either do this before the trial starts or they might do it in between the trial. Judges don't like to do it in between a trial because it pauses the trial and it makes the jury wait. So if they can get this done beforehand, it is most imperative to do that before a jury's trial starts. But as you saw in the Karen Reed case, there have been many voir dires that happened during the trial because shenanigans, we'll just say that. So they need to get a clarification as to exactly to what Mr. Jem is going to talk about. And if the defense is not clear, then they can call for a voir dire and the judge will have to rule on that. Mr. Faustow's, the Paramore statements, as you heard, that's not coming in. It's prejudicial. It's not to her state of mind. It's just to an overall observation. So that's not going to come in. So the defense won that one, which is really good. So again, it's one of those things that when you talk about it, somebody is afraid to ask a question. They're afraid they're going to get a no. But if you don't ask the question, it might be a yes. So ask, challenge, etc. So here we go. Let's continue on.
All right. Paper number 200 is Commonwealth 14, to allow the admission of text messages conversation as of 11/12. I wrote the defendant had not filed a written objection. I think I invited that at our last hearing, and I'm guessing that you didn't because it's 801D2 stuff, but you let me know if it's otherwise.
So, Your Honor, with respect to the text messages, I think maybe we have some objections to some of the portions of the text messages, but specifically, and I did talk about this in
Another paper?
defendant's response to Commonwealth motion in limb 13. The William Fastow text messages, I don't think that any of them are admissible and the jury should not receive them. There is no evidence about state of mind in them. It's text messages about two friends who are having an illicit sexual romantic affair. There's no evidence by the government other than speculation that Mr. Walsh ever even saw these messages.
Is it speculation? I mean, he says in his own words in the interview that somehow her text messages are showing up on my phone or something to that. And I'll go back and listen specifically, but we did cross this issue once before, and that was my recollection. Maybe it's a failed recollection.
No, the statement that you're referring to, there is a conversation between Mr. Walsh and the police where in the same paragraph, he says, I'm messenger, not I message. And then there's talk of Facebook messages popping up on its phone. So I don't think it's clear. And even if the court were to infer that iMessages came to his phone, there's no indication that those came to his phone. The text messages with Anna Walsh and Will Fastow ended at about 10:30 on New Year's Eve. Mr. Mutlow was at the home until 1:30. He specifically said, either during an interview or his grand jury, that at no point did he see Mr. Walsh on his phone. He didn't see Mr. Walsh on his wife's phone. He, again, described jovial, happy, up until the time he left at 1:30. So I think it's a very thin speculation that he saw these messages. If a foundation is laid during trial that indicates that he did see them or he did know them, it would be different. But otherwise, these text messages are hearsay and they're not admissible for any purpose.
How are they hearsay? In order, and what I'm focusing on is what in them, is to prove the truth of the matter asserted.
Well, then
I guess we'll have to look at each, and that's sort of where we're going to end up with the transcript, I suspect.
Well, then that's it. So it kind of reverses the question back to the government. Why are they seeking to put this text message history in? They're putting it in because they want to wave it around and say she was having an affair and he knew and he killed her. That's what they want to do. And I think if there was actual evidence or proof, other than speculation, that he had seen these messages, was angry about them, we'd be in a different posture. But that is not the case. And so why are they trying to put them in? And hearsay, her messages, her statements are hearsay. So what other purpose is it coming in for? I don't see a purpose other than to just wave this in front of the jury. Mr. Fastow is going to testify. He can certainly testify to the relationship between him and Anna, the duration, the time, but those text messages should not go in front of the jury.
All right. Kamal.
Please.
Your Honor, in addition to the defendant making statements about her iMessenger appearing on his phone, he also told the police that her phone was upstairs on New Year's Eve. He told police about some quarrel she had had with someone over text message, and then had been put her phone upstairs in their bedroom.
Abdullah.
Yes. That's different than Mr. Mutlu's testimony that she was using her phone all night. So I suggest that's certainly.
Let me ask you this. Based on the forensic work done on the defendant's phone, is there any evidence that he was on his phone that night?
No, Your Honor, there's not.
Okay.
That's the phone that was
Missing.
misplaced.
Right. But you do have evidence, so this has been the subject of other motions, that on the first and into the second, that there was some manipulation of that phone to unlock it. So I guess what I asked you, and it was a sort of a void in my mind of whether there was any evidence that he was on his phone on the 31st. And the answer to that is no.
The first time his phone was manipulated was at, I believe, 7:35.
In the morning of the 1st. All right. Just trying to get the facts in my head. Well, more to follow on this as to individual text messages, and I want you to be focused on whether or not they are being offered for the truth of the matter asserted, and if they are, what your positions are, and see if you can make some headway on this.
Thank you, Your Honor.
So the defense doesn't want the text messages to come in because they're probably, again, like she said, what is the purpose of it? Is it to assert that he knew that she was having an affair and that he saw these messages and therefore he killed her? Is that prejudicial? She's saying, prove it. Prove that he actually saw these messages and therefore this goes to motive, right? And so she's doing her job to advocate for her client, again, nitpicking what comes in and what doesn't come in. But also on the flip side, you hear that, so it hasn't quite been resolved, right? Because I guess there's a lot of other nuances, other text messages, other things that may or may not come in. And so what she's saying is, listen, both you guys get together, come to an agreement about what's going to come in and what isn't going to come in. So the judge is sort of like if you, like little kids that are fighting, right? If you are fighting and they can't come to an agreement, that you come to the judge and say, we've been fighting about this and we have an agreement and we can't come to the agreement. So she then is the person that says, okay, I'm going to break it up and I'm going to rule this way. She is basically telling them, come together and you guys then need to figure this out for yourselves. Come together and figure out whether or not you guys can come to an agreement, what's going to come in or what's not. That's what's called stipulated. Means you both parties agree this evidence going to come in, this isn't going to come in. If they can't agree, they come back to court and then they go in front of the judge and she makes the ultimate ruling. Let's continue.
Oh, Your Honor, the only other thing with respect to the messages, and this could be an email instead of, I just wanted to, we can certainly check, but if I could have the government verify if the messages they are proposing to introduce between Mr. Walsh and the other witnesses, if they have been edited at all, because we have like pages of text messages over a couple days to various witnesses, and I don't know if that is just the chunk that they are taking, or if they went in and cut out any messages.
Okay. And by the way,
I'll talk to the council afterwards.
Okay.
by the way, this motion that I'm talking about, we started to talk about Mr. Fasto and Anna Walsh's text messages. But to the extent that they're the defendant's text messages, which were the subject of this, then that's in a different bucket in terms of evidentiary ruling. Maybe not as important to you either, which is why you went to the other.
Right.
Okay. Commonwealth's number 15 is to admit internet history from devices in the defendant's residence.
Your Honor, the government has produced 2 binders that they expect to introduce into evidence. One is a binder of the gray MacBook, and then the other one is a binder of, I only have 2. Are you gonna- Oh, okay, we have 3 now.
All right.
So we appreciate that.
Are these for my own, sorry to interrupt you, but are these similar, if not the same, from what came into grand jury?
They're not the same to what came into grand jury.
Okay, because I'm familiar with those from the prior briefings.
This is significantly more material than what came into the grand jury.
Okay. Is it the same sort of format, though? There's a search and then the result of the search?
No, Your Honor, this would, I would suggest, be from a Celebrate report, and we have copies here that we can give to the court to review.
Okay.
But the Celebrate report for the MacBook pulls from 2 different databases, so you see the same search twice or the same visitation twice.
So let me ask you this. I have some questions that I need to process in my head.
Yes,
The searches that are done, is there forensic evidence that shows that the searches were done on the MacBook Pro
yes,
and not on the iPad?
yes,
All right. That's what I suspected, but I haven't asked and nobody told me that. I assume that that was the case.
yes,
Because that was not the state of the evidence, as you know, at the time the case was indicted.
yes, Your Honor.
So, and from that time, and that is March of 2023 when the case was indicted, are you saying that the forensic work has uncovered additional searches beyond what was known at that time?
Yes, Your Honor.
Okay, and what's the volume of that?
So the MacBook report, that report that was generated is approximately 1,000 pages long.
Okay, is that where this search, I hate to be so graphic, but well, it's not that, this isn't that graphic, but this, in paper number 201, I learned of a search that I had never seen before, which is
We're objecting to that one.
right,
Okay,
so that was not part of the grand jury.
it was not part of the grand jury.
What is the date of that search?
That is, I believe, forgive me because there's so many, but I believe it's in and around Christmas.
So
It's before.
Pre-
Before.
January 1st.
Yes,
Is it around the same time as the divorcing,
yes, Your Honor.
around the 27th?
If I may, I have a cheat sheet for myself.
1227.
It's 12/27, Your Honor. And it is approximately 8 hours before the searches for divorce.
So, Your Honor, there were more searches and hits in general on this topic, as you might see on someone's device. This particular search, the name was, I'm trying to be, it was also about having a threesome and impregnating someone. There's multiple searches for porn. He is an adult male. So I think to just cherry pick this one, and
I don't care about the porn part, so to speak. I mean, that is it's inflammatory.
Okay, if you didn't laugh at that, I don't know who you are. I don't care about the porn part. I mean, he's an adult male, so that's okay. Oh my gosh. Oh, okay. So we just had a small laugh in that. Woo, Mr. Walsh, what do you got going on, buddy? Okay. That probably won't come in, but apparently he's had more than he's gone from one extreme to the other, divorce to impregnating people. Interesting. All right, let's go. Let's continue on.
But it's the second part of that search, cheating wife. So that goes to the issue that we just talked about before, about his state of knowledge and what reasonable inferences can be drawn from that search being done on the 27th. That goes to that is an argument with regard to his state of knowledge on the 27th as to whether or not his wife was having an affair, right? I could care less about the porn part of it.
no, I understand. I think that without getting into a semantical discussion about pornography, I think that there's millions of different interests, predilections of what people
Sure.
might watch or like, and I think that it wasn't just cheating wife. It was cheating wife has threesome and gets impregnated. So to say that could have been ancillary to what the content of the material was. So I think it's inflammatory. So when the
Right.
court,
So there's this body of evidence of searches now that are not in my mind because they were, and it's not that it's inappropriate, that's why we have these hearings. But what would be helpful to me is if the Commonwealth, A, can provide me with those searches, and B, if you know, and it's not too much additional work, identify, and maybe it will become apparent to me because there's only the list of what you knew at the time of grand jury is pretty much encapsulated both in the grand jury transcripts, but also in the affidavits.
Your Honor, we're prepared to give you the binders and a list of the items that we would seek to elicit at trial from the binders.
All right.
And we'd give that, of course, we've given the binders to counsel, but whatever we give to the court, we give to counsel.
And then if there are particularized searches that the defense is objecting to, I know you will raise them with me. And as a matter of logistics for how the jury is going to be presented, this is even the stuff from grand jury, which I printed out because I'm still old school, is binders worth of materials that I have still with me. How are you going to present this to the jury?
So, Your Honor, we have, that would be tagged as an exhibit, a binder, but then it can be
Viewed.
broadcast on these different monitors. So we can ask the witness about a certain entry in the report and put the entry on the screen and then have the witness testify from the screen saying, this is what occurred in this entry, according to the report.
All right. Just an awful lot of material for them to absorb.
We understand that. It's also important material to the
I
Commonwealth's case.
understand.
And so it's not an easy examination, but we do believe that it's important, and we've tried to make it as streamlined as we can.
All right.
Okay, two things here. So one, the defense is trying to argue, and I love it. I love it. So again, we talk about the clever nature with which you argue about whether things should be admissible or not. And she is saying, sure, Your Honor, yeah, he was Googling about divorce. But in this context, in this sandwich, right? He's got this porn sandwich, right? He's interested in XYZ, and then divorce, and then XYZ. So it's all one sandwich about porn, and so therefore it shouldn't come in, right? And uh she's like, I don't know if I quite buy that. So the judge is like, I'm not so sure about that. So I think she needs to kind of look and see like what other contexts are around it, find out exactly what he was searching before, middle, and after to find out whether or not that comes in. So that'll be an interesting thing to come in. Secondly, we're talking about Mr. Connor is talking about how he's going to present this digital evidence. And in this day and age right now, 2025, there is going to be digital evidence. We talked about your phone is going to tell on you, your phone, your computer, anything you do can and will be used against you in a court of law, right? So they're talking about how they're going to present this information to the jury and make it as compact as possible, right? So they've a lot of things coming in digitally. They've got all of these internet searches, they've got text messages, they've got GPS location stuff, Celebrite downloading stuff. If you've seen the Karen Reed case and talking about how's long to die in the cold, that it can be overwhelming for a jury, right? And when you are presenting a case, whether you're the Commonwealth or whether you're the defense, you want to make it as small, as compact, and to the point as possible, because otherwise you're going to lose the jury and the jury is going to miss that point. Now you've got some people who just continue to drag on and bring it out like Lolly did in Karen Reed's first trial about the snow. Everybody knows it snowed and everybody knows that they had gone to the waterfall and there was high top tables. I mean, that is a strategy, right? That's a strategy. You come in, I told you it's theater, and you come into this and you say whether or not how you're going to present this as theater, right? And if you're very charismatic and you're very passionate and you come in and you're like, do, juries appreciate that. If you're Mr. Lolly and you're lollygagging around, juries are going to get lost and they're going to be bored and snoring. And so whatever point that you're trying to make gets lost. So Judge Frenier is trying to say, hey, this is a lot of evidence. 3 binders of different digital information coming in. That has got to be extraneous. So again, this is why we watch this trial. That's why it's so exciting. How is this evidence going to be brought in, and how is it going to relate to you, and how are you going to find? So let's continue.
Your Honor, too, just so the court is clear, I believe the government's position is that they're going to put in 3 or 4 actual binders into evidence, so the jury is going to get a giant binder of 1,000 pages. And so at what point does that become cumulative and prejudicial when they just drop by? And I'm just saying, is there a way to streamline this, or is there a way to cull some of it? Maybe that's something we can all work on. I just wanted the court to be aware that that is the intention.
More to follow.
More to follow.
All right. Paper number 16, to introduce Axios Investigations, hired by Diana Walsh, December 28th, 2022. Defendant is opposing. So what is it? Is the Commonwealth just seeking to admit through a person presumably that comes from Axios, because Diana Walsh is not on the witness list?
Yes, Your Honor.
So
We listed her as a witness, Your Honor. We don't know if we're going to call her, but we did list her in an abundance of caution.
all right, I'll make sure that she's,
I apologize, Your
I
Honor.
don't think she's on there.
It
She's
could
not
be a
on the list.
clerical error. But
Okay, so keep that so that,
She's also present in the court right now, Your Honor.
well, do you want to do anything?
What? What? Whoa. Alert. What? Why is mommy in the court if she's going to be a percipient witness in this case? Wow. Oh boy. So I mean, I don't know exactly what the rules are, whether or not witnesses can be in the court versus when a preliminary hearing is going on and the jury trial hasn't come up. And I suppose at some point in time he talks to his mommy about his defense and stuff like that. But ooh, interesting. All right, so let's just see what they're going to say. So they're talking. Diana Walsh is Brian's mother. She hired when Anna was missing, she hired a private investigator to go to DC to try to find her. Um, Again, we don't know what Brian said to her, whether or not he told her that he had done this. We don't know exactly what she knows, what he doesn't know, etc. Um, and interesting that the defense said that they had left her off the witness list and that they may or may not call her. Again, did nice defense tactic there. Because the Commonwealth has to prepare whether or not she's going to come and testify. So they need to prepare and prep for what questions they're going to ask her. So the Commonwealth wants the investigator information in, and the defense says no. So let's find out whether or not this is going to come in and why. How is it pertinent to this case? And is mommy allowed to be in court? Let's see.
About that?
I didn't know she was on the witness list, so I didn't move to, I didn't move to sequester her for this hearing. So I didn't understand that she was going to testify, Your Honor. I apologize.
All right. So
I can tell you what I would intend to introduce at trial from Axios. It's just very simple, a contract.
Okay, so he's saying because if you're going to go testify in a trial, you're being subpoenaed to testify in a trial, you're not allowed to be in the courtroom and hear all of the testimony from everybody else because it could influence your testimony, right? Oh, such and such said this. Oh, yeah, that's my recollection too. That happened in the Karen Reed case. Time and time again, there was witnesses. There was the other case too, Donna Adelson's case. Yes, that there was a witness who was standing in the back of the courtroom and the defense didn't know that the witness was back there. And I think it happened twice. And the judge was just like, oh my gosh, like really? So witnesses cannot be in the courtroom when they are getting ready to testify. Now, again, this is pre-trial. This is before the trial starts. So my understanding was correct that witnesses are not supposed to be in the courtroom. So why don't they tell her to get lost, right? Get out. So I'm not sure why the judge doesn't say timeout. She needs to leave. Let's talk about this. But they're going to talk about it in open court. Let's ride. Let's go, law nerds. Let's go. Let's see what this is going to do.
That was executed.
right, which I've seen.
Yes,
It's a grand jury exhibit.
yes, Your Honor.
What's the objection to that?
So, Your Honor, what's the relevance of someone who the government isn't calling as a witness to introduce something that they did on the 27th of December?
Well, the relevance, and frankly, I'm going to ask that Ms. Walsh leave the courtroom.
Thank you, Your Honor.
Duh. I mean, come on. I mean, I just said it, right? Why is she in the courtroom? Hello? Hello? McFly? Hello? Oh my gosh. Oh my gosh. Did you see the Cardi B trial where, I don't know exactly what transpired. I just know only that clip that she's like, hello. Like she's waiting for like the defense witness to come up and ask her questions. So she's like, hello. Probably should need to insert that here. But it's just like common sense, people. And like the defense knows she's there. Like, why? Why? Okay. Well, I guess better late than never, right? Let's continue on.
I can speak more freely in a moment.
Mhm. Thank you.
So, Your Honor, The evidence that the government has provided us suggests that Diana Walsh contacted Axios Investigations on December 27th through email and phone calls, that she signed the contract, that she paid for it. In the grand jury testimony, Jeremy Dozier states that Diana Walsh specifically said, "I don't want my son to know about this." So they're trying to basically say, she did this. We have no evidence that he was part of it, knew about it, directed it, paid for it, and it's just prejudicial and
But there,
infringement.
I read somewhere, and it has to be in the grand jury, I read somewhere that the connection to the defendant is that she wanted to do this for some time because of the psychic, the whole,
Mhm.
and that she went to the defendant or said to the defendant, "I want to do this," and that he tried to rebuff her and say, "No, I think his words were, Anna's a good girl, and she's not having an affair," something to that effect. But then I also read somewhere, has to be again in the grand jury, that he then gave her the name of Axios. So even though he said don't do it, he gave her the name of the company that she hired, right?
So if the government is going to elicit that information,
That the only way that comes in is through Diana Walsh.
and they did not list her as a witness. So even if there was evidence that the government was planning to introduce that Mr. Walsh supplied the name, that doesn't indicate he paid for it, knew that she finally did it, was interested in the results. The evidence we do have is that the mother saw a psychic, and even the testimony, or excuse me, the evidence suggests that when Mr. Walsh was speaking to other people about it, he was dismissive of it and even told his wife about it. So I don't think it's appropriate that they get to introduce the contract or the fact that Diana Walsh hired a private investigator on the 27th unless they're going to call a witness to link it to him and that he knew about it, wanted it, and was invested in the results. Otherwise, it's not relevant.
So, Your Honor, you were right about your memory of the grand jury testimony. That statement of the defendant giving the name Axios, that comes from his mother. So
But you don't have her on the witness list, so how do you make that connection without her?
that's fair. We were suggesting is a reasonable inference by the amount of contact the two of them had, and that he saw her frequently, and that he talked to her frequently over the phone. But again, we were trying to be very limited with what we were entering. It was just the contract through the private investigator. So with that, I think Ms. Porges, her assessment of the evidence is correct. And so I don't want to belabor this issue. That was the only thing we were trying to get. We're not trying to get any statements of the defendant, nor are we trying to get any statements of his mother, simply the contract.
Well, you make whatever strategic decisions you're going to make, but that may lead for a paucity of evidence on linking his knowledge to it. That's your choice.
Understood, Your Honor.
All right.
Okay, so is that going to come in? It is unclear whether or not that is going to, he just wants the contract to come in. And he's saying it's kind of like cheese, right? You leave cheese out, you leave crumbs out for the mouse, and the mouse goes and takes the bait, right? So if the statements that if they can bring in the statements of kind of what Brian Walsh knew from various people, from his text messages, whatever, through his statements he made to the police, if they can sort of connect those dots, then perhaps they can go ahead and they can get just the contract in. If Mrs. Walsh testifies, well, then it's fair game, right? So perhaps the defense is using that as leverage. Well, we might bring her in and we might not, depending upon because the Commonwealth goes first. They put on their case. Then the defense then rebuts it with their case. So depending upon what the Commonwealth brings in, do they need to bring in Brian Walsh's mother, Diane, to find out whether or not it's going to rebut anything that happens? So it is unclear. So they're going to have to, it's like one of those things they're going to have to argue as they go along. So let's continue.
Number 17 is paper number 203, and no objections to the calendar.
There isn't, Your Honor, but given the fact that there is, my understanding is that there's going to be a blank calendar and items or notations may be placed on it, and I'm assuming then that is going to go to the jury.
Mhm.
If that's the case, then the defendant would also like access to also add or denote things on that calendar, and we can color code it, we can figure out a way, but that's what I would ask for. Or we can have two calendars, which seems superfluous if there's one.
We were just looking to give each juror an empty calendar so they can make their own notes and it would be part of their notebook, not something like that witnesses would be using.
So if
Okay.
they just want to give a blank calendar to the jurors so they can keep track of days, then that's fine.
Yeah, it just got confusing during the grand jury.
All right. 206 is allowed, sequestration of witnesses. 207 is a review. Commonwealth took no position.
Your Honor, may we be heard sidebar?
Yes.
Okay, interesting. 207 is a view. I'm assuming that they want to take the jurors to the house in Cohasset to go view the surroundings and stuff. Now, obviously, when they go do this, it's not the exact same. It doesn't have the same furniture, et cetera, et cetera, et cetera, inside it. And it might be empty. Like, does somebody still live there? So, or maybe they're just going outside to view. I'm not sure. So they're going to sidebar to discuss this. So we'll see kind of what they have to say in reference to this. All right, so let's zoom.
.208 is defense number 3.
Your Honor, with the court's permission, is it okay if Ms. Walsh comes back in?
No objection.
Sure.
Thank you.
So paper number 208, which is now we're moving to, did move at paper number 206 to the defense's motions eliminate. Paper number 208 is
I guess
defense
they
number
asked if
3.
mommy could come back
That is now
in.
mooted
Oh, here she
and
returns.
requires no ruling. Paper number 209, defense 4. Commonwealth has indicated they will not seek such opinion, so no ruling is needed. Paper number 210, defense number 5. Commonwealth will not seek, no ruling is necessary.
Your Honor,
Mhm.
might we ask that a similar order regarding any awards or commendations for any defense experts that may be called? That they may not elicit that from those experts?
Well, to the extent that it goes to their qualifications, they need to do that. They need to know that the person's qualified, but no excessive lauding. How about we say that? On either side. Paper number 6, defense's motion in limine regarding
Okay,
any
we
opinion
get it.
that
There's
the
mommy.
defendant
Let's
knew
get
about
back
the
to
extramarital affair.
the people.
And that was opposed by the Commonwealth at paper number 230.
Come on, let's get
And
back to
as
the
I
judge,
understand the
please.
respective positions of the parties, is the Commonwealth's position is it's not seeking an opinion as to that, but is going to plant breadcrumbs such that a jury could
Okay, do not
or could
focus
not,
on
but
her
they're hoping they
writing.
could
That is
infer
not
the same.
nice. Come on, let's get back to where we're
That's
going,
right, Judge.
please.
They've told us they're not eliciting an opinion, so that
Right.
answers that.
So that seems to be the line that the rules of evidence draw as well. Paper number 7, defense number 7. What did I write here? Oh. Is paper number 212, and it's regarding opinion evidence. And the opposition was at 231. And I wrote to myself, what more do you want? And under what authority?
Well, all I'm trying to do, Judge, and all we're trying to do is keep these witnesses from taking the stand and start offering opinions as opposed to the facts of their investigation, that they not be asked opinions that they have not provided in all of these reports. Because when you read through the hundreds of pages and what they've given us is all this search data and everything, that's fine. But they can't then elicit, do you have an opinion about what this means? They can't do that, and that's why we filed this motion. That's all.
That's interesting. Okay, so if we go back to the preliminary hearing that we had, the evidentiary hearing, and we're talking about the police officers, I guess what he's trying to say is they can only attest to what they found and not their opinions, which I find interesting because it's sort of like the breadcrumbs, right? Well, if you see this, what does this mean? And where does this take your investigation? Let's see what the Commonwealth has to say, whether or not they agree or disagree with this. Interesting. Okay, we're going to see how this plays out.
I'll hear from the Commonwealth.
Thank you, Your Honor. Your Honor, we've provided voluminous discovery in this case. Certainly, we expect that the witnesses will testify as to what they did in conformance with their reports. They'll explain their reports to some extent, but the defendant has all this material that has all been provided. So we would, if there's something specific they're looking for, but again, the witnesses will not stray beyond the reports that have been provided.
All right, then we have no disagreement. As an aside, by the way, it is somewhat surprising to me as I was looking at this issue, how little is said about experts in the context of, or how little is required by the rules in stark comparison to the civil rules. And I can't resolve that in my mind, why the drafters of these rules sort of make a heavier burden on the parties in a civil case with regard to expert testimony than is expected in a criminal case. I don't know why. Curious.
If I may?
Yes.
I suspect it's because in criminal cases, you have procedural due process bumping up against substantive due process, and that's not present.
Wouldn't you think that would then err to the side of more disclosure for the defendant?
I think less because fair trial strategy, and that might be different. That would be my thought.
My thought when I was sitting in the back is, why don't they have to produce what they have to produce in a civil case? But I don't write those rules. I just try to interpret them.
I don't want to belabor this point at all, but I remember Stephanie Page filing motions for depositions because you allowed depositions in civil cases.
Right.
And we were always shut down saying no, and we asked the same question the court's asking.
Well, I'm asking that question, and I almost never allow depositions in a civil case, even of the experts, but regardless, it's just a curiosity. Anyway, defense number 8, paper number 213, opposed at 232, and then another rebuttal at 281. To exclude defendant's request to consult with an attorney or statements of prior counsel. And I got more on that today, I think, too. Let's pause on that one. Bad acts, 214, paper number 9 for the defense. I think we've discussed this. It's opposed by the Commonwealth in a partial opposition of paper 233. And I had written to myself in my notes, question to the defendant specifically, what additional statements from the recorded interview does he want to exclude? But we're going to get to that in a minute. Paper number 215, defense number 10, motion in limine regarding witness characterization of evidence or of the defendant's behavior. The Commonwealth has said it will not seek character evidence, but will offer evidence of the defendant's behavior through observations. Is that right?
Yes, Your Honor.
All right, that seems reasonable and likely where the line's going to be drawn. Number 11, paper number 216, asking the Commonwealth to designate and provide notice of specific statements and internet searches contained in the digital data seized to be introduced at trial. Anyone wish to be heard more on that issue?
Your Honor, the Commonwealth did file a responsive pleading, paper 234.
I saw that. I will say that the Commonwealth's opposition at 234 seemed to take a reasonable approach. And likely where the line will be drawn. Is the pillowcase and the pillow, that's all over, right? There's nothing there.
We're not going to introduce it, Your Honor.
And there's nothing other happened with regard to the, this is just a hanging, dangling from the prior motions, the dinosaur, teddy bear, that's nothing I need to worry about.
Nothing you need to work on. We sent counsel a list of photos we were intending to introduce. I think that we cropped out any images like that. And so if there's any issues, they'll let us know.
All right. So how do we take on this, what the remaining issue that I really want to address today, and then I'm happy to talk to you about anything that you need to discuss with the court, is these transcripts. And I had about 5 minutes to look at the case that the Commonwealth has now cited in its most recent briefing of this morning, and I want to give it a closer look. But one way that we can approach this is to literally go line by line. I know that the defense has indicated, and I appreciate the way that this was laid out in the briefing, because it makes it very clear as to what it is that you're seeking and helpful. So I appreciate the work that you did to get that in that shape. And you've stated your objections. So one way I could do this is to just go through on this list that you gave to me and rule at some time between now and before the evidence is played, and give you a little bit more time to brief it. I will say that as I said to you at the side of the bench on Friday, but I think that there's a evidentiary issue that needs to be decided with regard to what the scope of the employment of Ms. Minor was. And I'm not sure how this new law fits within that analysis. If it does, if it's just a separate analysis, it almost seems like it's a separate thing completely. And a separate vehicle or avenue to admissibility, these adopted admissions. But I want to give the defense time to respond to that because it just came in this morning. And as to many of these statements, and so that you don't misunderstand where I thought I was on Friday, which was alerting you to the issue of agency, I'll call it. And I don't want either of the parties to be misguided by what I said to you on the side of the bench with regard to that. And what I mean by that is this. Even if Attorney Minor's statements aren't coming in, even if they weren't coming in, I never intended to not allow the Commonwealth to tell the jury that she was present there. So whether her statements come in is very different than whether her attendance at the interview was going to come in. And I think in the opposition that I saw, the papers that I saw flying, I think the Commonwealth, maybe based on what I said at the side of the bench on Friday, thought that I was excluding the latter as well. That is, her attendance at the interview. I also want to remind you of something that I said at the side of the bench on Friday, which is much of what Attorney Minor says is repeated by the defendant. And so the cumulative impact of those statements is not significant for the most part. There may be statements that she makes that are significant. It seems to me, and I'm sure the defendant is going to ask for the humane practices instruction. And if that is the case, it would seem to me that the dynamic of what is going on in that home during those interviews is relevant to that, specifically Thomas's role. I see you nodding your head no, but then I get to the later interviews. Maybe there's not enough in there for you to care about it. So why are you nodding your head no over there, Attorney Tipton?
I appreciate the time to respond. I was reading their cases at 4 a.m. That's not the best time to be reading cases. If the court...
I was blissfully ignorant of it at 4 a.m. I didn't see it until 7 a.m.
So if the court's, we will file a written response. My understanding is this court's going to give us time for that. And when's a good time to have that filed? You said you would make a ruling before the evidence started. So
Right.
I'm just wondering.
I mean, honestly, the next couple of days, we're going to be busy with picking a jury and maybe even longer than that. So, I mean, I don't, as long as I rule on it. Yeah, as long as I rule on it in time for you to make the appropriate edits and I don't ruin, the poor IT person that's going to be tasked with doing the edits Thanksgiving. How deep into the case are these transcripts coming in?
Potentially the first day, Your Honor.
Well, great, thanks.
But the good news is like you said, a lot of it was cumulative. And so in going over that, particularly the interview in the 7th, when we looked at it, like, there's really not a big problem with a lot of these. So we'll start working on some of those redactions. And we gave a list to the court of the things that we didn't object to. So we're going to start working on this.
So curiously, and I just want to make sure that this was a conscious decision on the defense's part and not something that was unconscious. There's some of what she said that you kept in. You know that. What attorney?
No,
There are some statements that you did not ask to be, and so.
From Tracy Minor, Judge?
Yes.
Well, then that was an error. That's the highlight didn't carry through. Then.
Okay, all right.
Because, and I don't want to interrupt the Commonwealth, and we're going to file a written response. Let me just lay the groundwork for it, though.
Sure.
The court brought up the humane practice. We footnoted in a pleading. We never asserted humane practice. We're not asking for humane practice. Okay?
All right.
That is the bottom line here. And the Commonwealth's citation to sheriff in their latest briefing, they misstate what the law is. The law is if humane practice is a live issue, the court is required by law to give it humane practice. It's not a live issue. We've never raised it. So I want to set that groundwork.
All right, I appreciate that.
2, I understand what the court just said about you never intended to indicate you were going to exclude the presence of Tracy Minor. Our prejudice, contrary to what the Commonwealth argued in their brief, in their memo they filed last night, we made it very clear what the prejudice is. The prejudice is from the fact that Tracy Minor is there and all these statements are being made. Not the statements necessarily of Tracy Minor, but the statements of the client. And we made clear what we think the prejudice is. And that prejudice, once again, we'll lay it out in more detail, But that prejudice is the same type of prejudice that flows from the Commonwealth's reaction to Proctor and I won't go into anything about Proctor except for the fact that once Proctor's integrity was impeached, the Commonwealth moved away from it, moved away from him. Why? Because his impeached integrity reflected on this office, the Norfolk County District Attorney's Office. Our prejudice is that what happened at these interviews, that Tracy Minor was there, that the jury can take that to say, as we said, either he's lying to his attorney, therefore he's lying to us, and they can't believe our representations during the trial, or his attorney was complicit in the misrepresentations he was making to the police because she chimed in, but she was there. And so now we're making misrepresentation on his behalf. That's the type of prejudice we're trying to avoid. And finally, we're going to be arguing, why is it relevant, especially when you take the humane practice out of it? There is no relevance to Tracy Minor being there. So we'll brief it, but I wanted to lay the groundwork for that.
All right. So I appreciate that preview, and I appreciate the.
Welcome back to Legalese 1, 2, 3, where we are covering cases across America. Okay, I don't know why that did that again. I paused for a second because I needed to go run to the bathroom. But I had to take my green thing off. I got my Snoopy shirt on today. Long story short, oh my gosh. That was a bomb. So we wanted to know how is Proctor going to come into this, right? And so I paused and we're going back. So we're going to go back and we're going to listen to this again because I need to process, what did he say? What are our context clues? What's going to happen with Proctor? So let's listen to it again.
From Tracy Minor, Judge?
Yes.
Well, then that was an error. That's the highlight, didn't carry through.
Okay. All right.
Because, and I don't want to interrupt the Commonwealth, and we're going to file a written response. Let me just lay the groundwork for it, though.
Sure.
The court brought up the humane practice. We footnoted in a pleading. We never asserted humane practice. We're not asking for humane practice. Okay?
All right.
That is the bottom line here. And the Commonwealth's citation to sheriff in their latest briefing, they misstate what the law is. The law is if humane practice is a live issue, the court is required by law to give it humane practice. It's not a live issue. We've never raised it. So I want to set that groundwork.
All right. I appreciate that.
Two, I understand what the court just said about you never intended to indicate you were going to exclude the presence of Tracy Minor. Our prejudice, contrary to what the Commonwealth argued in their brief, in their memo they filed last night, we made it very clear what the prejudice is. The prejudice is from the fact that Tracy Minor is there and all these statements are being made. Not the statements necessarily of Tracy Minor, but the statements of the client. And we made clear what we think the prejudice is. And that prejudice, once again, we'll lay it out in more detail, but that prejudice is the same type of prejudice that flows from the Commonwealth's reaction to Proctor and I won't go into anything about Proctor except for the fact that once Proctor's integrity was impeached, the Commonwealth moved away from it, moved away from him. Why? Because his impeached integrity reflected on this office, the Norfolk County District Attorney's Office. Our prejudice is that what happened at these interviews, that Tracy Minor was there, that the jury can take that to say, as we said, either he's lying to his attorney, therefore he's lying to us, and they can't believe our representations during the trial, or his attorney was complicit in the misrepresentations he was making to the police because she chimed in, but she was there. And so now we're making misrepresentation on his behalf. That's the type of prejudice we're trying to avoid. And finally, we're going to be arguing, why is it relevant, especially when you take the humane practice out of it? There is no relevance to Tracy Minor being there. So we'll brief it, but I wanted to lay the groundwork for that.
All right. So I appreciate that.
Okay. Oh boy, lots to unpack there. Okay, so he is comparing Proctor's, he's comparing how the Commonwealth is going to handle Proctor and and then comparing that to how he is how Tracy Minor Tracy Minor was his attorney at the time in the fraud case, and stating whether or not he was lying to Tracy Minor or Tracy Minor was lying to them. Ooh, that's going to be very interesting. Let's see how this plays out. Let's see what they have to say. Ooh, it's getting good without even the trial happening. Woo! Hold on.
Preview. And I appreciate the reminder with regard to the humane practices, both for myself and also to the Commonwealth as we move forward and try to resolve this issue for you.
And could I just make one more suggestion? If the Commonwealth could take the highlighted sections that we provided to the Commonwealth and you,
Yes.
and just now go take those highlighted and maybe color code all of these statements they've listed, wouldn't it make it easier for us all?
Well, I think
just
we
to
can
look
get
at?
down to, I think if you get rid of the cumulative stuff, you're really probably down to not a lot.
Right.
So that might be a good idea. What do you think about that?
I think you're right, Your Honor. I think that the issue became with the transcripts. Once you started taking her out, it became confusing. So she would actually ask a question and he would answer it.
Right.
Or she would correct him on the restitution figure 3 times in a row. So then he's just shouting numbers out. And it doesn't make sense. So a lot of it was just confusing with what was being proposed. So we're trying to go back and be more strategic about this.
All right. And so my goal is to make things clearer and easier for the jury
Yes.
than confuse them. And so to the extent that that you're having that situation where there's a question that she's asking that he's answering, and it's cumulative, the relative prejudice, I understand the argument, and I'm not ruling on it right now, Attorney Tipton, because once she's there for one answer, she's there, your argument is going to be the prejudice attaches. I understand the argument. But it's also incumbent upon me to provide evidence to the jury that they can, in a manner that they can consume it. And if it's doing so, once I balance the prejudice in a way that allows them to digest the evidence, but I'll think more about the prejudicial issue. And maybe you can get, there really is not a lot that she says that he doesn't repeat. So how about Friday on that color coding?
Yes, Your Honor.
All right. That's all the motions eliminate, right?
Yes, Your Honor.
All right. So, not much else that I have other than the jurors that were called in today were being used for a civil case. They're going to be told at the end of the day that they're being held over till tomorrow. And that's so that we will get a big yield tomorrow and hopefully I'm hoping to take 70 of the jurors tomorrow, and the remainder will go hopefully to Crim 2 so that they can get their work done too. And then every day they're going to be held over. So we will have jurors right through till Friday, because as you know, typically we don't get jurors on Friday. And we'll seek to 16. Any questions that you have lingering that you need answered between now and tomorrow morning on anything?
No, but I would ask to come to sidebar on an unrelated matter to this case
Okay.
when the time comes.
Anything the Commonwealth needs?
No, Your Honor, I think that we'll work together and try and figure out some of the other issues we've talked about today. I've been keeping a running list and just trying to make sure that we stay on schedule.
All right. I will see you at the side of the bench.
Okay, let's zoom to see if there's anything else that they put on the record. All right, hold on just a moment.
So the plan is we'll see each other. We'll end today's work. I appreciate the commitment to do some further work on issues, but I think we're really in pretty good shape
Yes, Your Honor.
as we move forward to the start of this. I will get you later this afternoon what I believe is the most updated witness list, which will be attached to that supplemental questionnaire. Take a look at it carefully, and I made some changes, some other minor changes that you'll see in there.
And I think we'll be able to give the court the binders of the internet stuff with spreadsheets of the isolated ones that we're looking at.
All right, that sounds good.
Thank you, Your Honor.
Have a good day, and we'll see you back here at 9 o'clock tomorrow morning.
You as well, Your Honor.
Thank you. Matters continue to November 18th at 9 a.m. Thanks, everyone.
Okay. Oh my goodness. Wow. So a lot to unpack there. So the first things first is that this is what's called the pre-trial conference hearing, as you heard. They go back through all of the motions, and basically the motions are, I want this to come in, this can't come in, this is prejudicial. These statements are hearsay. They don't go to the matter asserted. Just a whole bunch of legal jargon, etc. You did actually get a small brief of like so in law school they call it like L101. So you got a brief question from Judge Frenier from the bench about why it's more critical in a civil case for you to get a full description and information as to what a it's escaping me, what a person is going to testify to, an expert's going to testify to, than in a criminal matter. And you heard from both the defense attorneys as to why they think that's the case. And I find it was really interesting as a matter of case law to discuss it in open court in a criminal trial against somebody else. All right, so we're just going to do a small recap today. As you know, we're getting ready for jury selection in the Brian Walshe case. What does that mean? So right now they're just going back and forth, the defense and the Commonwealth, to make sure what's going to come in, make sure there are no surprises, make sure the exhibits are well marked, make sure that they have the technical issues, what internet searches are going to come in, what hearsay statements are admissible, what isn't, what is Diane Walshe, whether she's going to testify, is the information into the investigator going to come in. There are still a lot of unanswered questions. Some of it will be depending upon what the defense and the Commonwealth bring in and what's going to be elicited from that. Some of it has already been ruled upon. Statements from Mr. Fausto, the text messages are not coming in. But just remember, just because she rules right here and right now that this isn't going to come in, doesn't mean that maybe at some point in time somebody says something on the stand, and when you do, you open up the door. That's what they say. Oh, they opened up the door, Your Honor, so now we can bring that in. And that's kind of like it's a big faux pas. So I made some little notes here that very important. No social media for the jury. Jury is going to be given an instruction that they are not allowed to be on social media at all during this trial. That'll be interesting. The elements of the crime are still in dispute. So that is something that has to be ironed out, because in the beginning, when they talk about who's who and what's what, they usually talk about what he's being charged with, et cetera, and how that fits with the evidence that's going to come into the trial. So we need to know what the elements they're going to bring in. Proctor, whoa. So I wasn't expecting, I heard little elements of Proctor, something sort of underlying coming in when we were talking about what opinions are going to be coming in from experts and like police investigators, that they are not allowed to elicit anything other than what's in their report. So we'll see how that comes to play. And I was like, oh, I wonder if Proctor's sort of in that mix. But then when Tipton got up and made a soliloquy of, wow, he was very passionate about how the DA's office is distancing themselves from Proctor, and they pretty much want to eliminate him as much as possible. And obviously there is some stuff that is very pertinent to Brian Walsh's case in reference to perhaps Proctor's bias. Proctor said a lot of things in reference to Karen Reed, disparaging her and her character. And it's one of the reasons why he was fired was his bias in her case. Is there a bias in this case? And how is that going to come into play? And I don't know if it's not coming in. I don't know if it is coming in. So that is going to be a huge play by Tipton. I cannot read my I guess what is coming in 231. What is the attorneys asking for in reference to parsed information from internet searches and stuff like that? They're going to have to figure that out. She did state that they're looking for a juror of 16, and how quickly are they going to get that? Remember, tomorrow they are going to start the voir dire process. She talked about they're going to have about 70 potential people coming in, and what is that going to look like, and who's going to be seated and when. Remember, they are trying to get a jury seated. If not by the end of this week, then they will continue next week. Sorry, I had a hiccup. Continue next week, either Monday or Tuesday, and hopefully get a jury seated by then. They want to start jury trial on December the 1st. So how's that going to work? I don't know. We're going to wait and see. So I'm going to go ahead and end things here. We'll keep you updated on the next information as to coming out with this trial. But this trial is slated for trial jury on December the 1st. So we'll keep you updated. Stay tuned.